Thank you. That concludes topical questions. The next item of business is a debate on motion 19866, in the name of Jenny Gilruth, on the children, withdrawal from religious education and amendment of UNCRC Compatibility Scotland Bill at Stage 1. And I'd be grateful if members who wish to take part in the debate were to press their request to speak buttons now. And I call on the Cabinet Secretary to speak to and move the motion.
Presiding Officer, I am pleased to present the Children Withdrawal from Religious Education and Amendment of UNCRC Compatibility Duty Scotland Bill. This bill is a really important opportunity to strengthen the rights of children and young people in Scotland, building on our commitment to the UN Convention on the Rights of the Child. Firstly, I want to thank the Equalities, Human Rights and Civil Justice Committee for its careful and considered work on the bill and for their Stage 1 report. I very much welcome the fact that the majority of committee members supported the general principles of the bill. However, I also acknowledge that members had a variety of views on the bill's measures and that not everyone is in agreement on both parts nor all provisions. I recognise why that might be. As I stated in evidence to the committee only last month, these issues are very finely balanced and sensitive for many people, and I want to assure the committee and Parliament today that I look forward to further constructive engagement on the issues that are raised. I'd like to thank the stakeholders who have taken the time to express their views on this bill through evidence to the committee, the public consultation and my own engagements. Yes, I will.
Alex Cole-Hamilton.
I'm very grateful to the Cabinet Secretary for taking my intervention. Liberal Democrats will support this bill tonight, but we share the concerns of stakeholders both in this chamber and beyond it who have considerable concerns about Part 2, the failure by this government to make the case for what seems to be a dilution of our commitment to incorporating the UNCRC.
Cabinet Secretary.
I thank Mr Cole-Hamilton for his intervention. I'm going to come on to talk to Part 2 later, but I do recognise, and there are a number of different views, particularly in relation to Part 2, in relation to stakeholders' views on this, but I will continue to listen as the bill makes its way through Parliament to that end. The bill does serve two main purposes. Firstly, to strengthen children's rights in decisions about religious observance and religious and moral education. Secondly, to clarify the legal duties of public authorities under the UNCRC Incorporation Scotland Act 2024 in situations where provisions in acts of the Scottish Parliament conflict with the UNCRC obligations. The bill is technical in nature, dealing with these two separate but related objectives set out in parts 1 and 2 respectively. As such, the bill has been drafted very narrowly, deliberately so, as the bill is intended to address these specific points within the current parliamentary session. However, I want to assure stakeholders and children and young people themselves this bill does not mark the end of our efforts to strengthen and improve children's rights. Presiding Officer, religious observance and religious and moral education are two distinct but important aspects of school education in Scotland. Sections 8 and 9 of the Education Scotland Act 1980 provide for the long-standing parental right to withdraw a pupil from religious observance and/or religious and moral education. Guidance on religious observance notes that pupils' views should be considered in the withdrawal process. Currently, however, there is no requirement in legislation to do so. The decision rests entirely with the parent. Part 1 therefore proposes to change that to provide a legal right for a child to be consulted where a parent has made a request to withdraw him or her from religious observance. This would provide certainty in the law that children and young people's views should be considered when parents are exercising their withdrawal right. It does not introduce an independent right to withdraw for the child, nor alter the parent's right to request a withdrawal. In practice, it also gives the child the ability to opt back in. Without these changes, pupils may be denied these aspects of their education against their wishes, and their rights under the UNCRC may not be upheld. The committee has heard divergent views on this topic. Given the plurality of these views, the government's approach aims to chart a middle course, that is to strengthen children's rights while balancing the three considerations of parental rights, recognising stakeholder views and practical implications for schools. I'm happy to give way to Mr Whitfield.
I'm very grateful to the Cabinet Secretary for the plethora of choice that she had at that point. What is the government's position? Because the Cabinet Secretary has already spoken about the complexity between education and religious observance. What's the Scottish Government's position on how those two dichotomies are going to be addressed by this middle way?
Cabinet Secretary.
So I thank the member for his intervention. This was a point the committee has raised and reported on. At the current time, the 1980 Act does not separate these two distinct parts of our education system, but I do think it's something we may want to come back to at stage 2 and reconsider. I would, though, say that in stakeholder consultation there were mixed views in relation to how that might be undertaken, and the parental right to withdraw as well, perhaps not applying to certain aspects in the future. So we would need to be mindful of that at stage 2. And I'm also mindful, as Mr Whitfield will know, that we're making good progress in the curriculum improvement cycle in this space. So all of these things need to be considered in the round. Presiding Officer, if I can turn to part 2 of the bill, which Mr Cole-Hamilton alluded to earlier, the UNCRC Act requires public authorities to respect and uphold the rights set out in UNCRC requirements in the Act when they exercise functions under Acts of the Scottish Parliament. It places a clear duty on them not to act incompatibly with those rights, and it gives children and their representatives a route to challenge decisions and seek redress. To ensure that duty operates fairly in every situation, the bill introduces a very narrow exemption, where another Act of the Scottish Parliament leaves a public authority with no discretion to act compatibly with the UNCRC requirements. The public authority would not be in breach of the duty for doing what the law requires. Yes, I will.
Stephen Kerr.
Cabinet Secretary for giving way. Can I go back for a moment to the issue of the rights of the child? I understand that that is a focus of her speech. But she said in this bill there was a balance in terms of the rights, responsibilities, legal, of parents. How does the bill at all address that, given the fact it gives the child the right, as prompted by the school, to decide for themselves something that their parents, who have a legal duty to them, will have already decided?
Cabinet Secretary.
I'm not necessarily clear that I follow Mr Kerr's line of questioning. The Act, the amendment essentially that's being proposed in the 1980 Act, does not allow the independent right for children to withdraw from religious observance or religious education. Any withdrawal from those subjects or that observance in school has to be initiated by the parent or carer. So it's not about taking rights away from parents. What the legislation does propose is that we put into law the requirement for the child's views to be taken cognizance of. Now, if I can return to part 2 of the Act, Presiding Officer, I mentioned the safeguards that will be put in that regard. But if we had not put in these safeguards at part 2, a public authority could be put in an impossible position, compelled by law to act in a particular way, while also being told that to do so would breach the compatibility duty, creating a conflict that could lead to disruption or even a pause in vital services. So the exemption avoids that by allowing services to continue. We do not believe any current acts of the Scottish Parliament require incompatibility action. There should also be no future acts of the Parliament that require incompatible action because of the safeguards for new legislation built into the UNCRC. But this is about future-proofing, and our understanding of children's rights will continue to develop over time, and court judgments, of course, can also shift interpretations over time. In short, while we do not see any compatibility now, we cannot rule out the possibility of it arising in the future. So the risk to essential services is material, and it is not one the Government is willing to take. Importantly, though, I will do. I'm mindful of time, Presiding Officer.
Martin Whitfield.
I'm very grateful to the Cabinet Secretary giving so much time to interventions. Does the Scottish Government recognise that the potential of the exemption that's being created in this bill could be replicated in future, but actually, and possibly more importantly, will turn any case that an individual young person has with regard to their human rights as back against this legislation rather than the Council, and thus making it a far more complex way of trying to enforce their children's rights?
Cabinet Secretary.
I thank Mr Whitfield for his question. In relation to this being replicated in other legislation, it's important to say that a similar safeguard already exists in relation to the Human Rights Act, and the approach we've taken here is much narrower and more targeted, so we believe that allays the risk that the member has spoken to. Now, a number of stakeholders, including Together, the Children's Commissioner, I'd like to make some progress, but I'm happy to take interventions in closing, and children and young people have been broadly supportive of this approach and have recognised that where the issue lies in legislation, the focus should be on fixing that legislation. Presiding Officer, I have carefully considered the points and the recommendations made by committee in the Stage 1 report, and I've responded formally. And I'm mindful now of time, Presiding Officer, so I will move to concluding comments, if I may. In summary, Presiding Officer, this bill builds on the progress that we continue to make on children's rights. It strengthens the protection and promotion of children's rights in education and strengthens the legal framework for children's rights in Scotland. I do recognise, I think as we've heard this afternoon, there are a range of views in these areas, but this bill offers Parliament a very clear opportunity in this session to make further meaningful progress on children's rights. I welcome a majority of committee members' recommendation to agree to the general principles of the Children Withdrawal from Religious Education and Amendment of UNCRC Compatibility Scotland Bill, and I hope that Parliament today agrees to the general principles. I move the motion in my name.
Thank you. I now call on Karen Adam on behalf of the Equalities, Human Rights and Civil Justice Committee. Up to 9 minutes, please.
Thank you, Presiding Officer. I welcome the opportunity this afternoon to speak in my capacity as convener of the Equalities, Human Rights and Civil Justice Committee on this bill. This is a short bill with two main purposes. On the face of it, it appears to be quite limited in scope, and to some extent it was presented to the committee as a technical bill. It has, however, been an immensely challenging bill for the committee to consider. There was not one stakeholder we heard from who offered unreserved support for it. As I will return to at the end of my speech, ultimately a majority of members have decided to recommend support for the general principles of the bill, but it has not been an easy decision to reach, and a minority of members have either been unable to make a recommendation on the general principles or do not support the general principles. Irrespective of the view we came to on the bill, we all recognise that there are many serious concerns about the bill. And if the bill does progress to stage 2 today, then it will have to be amended to respond to those concerns. Moreover, since we reported, the UK Supreme Court has issued its judgment in relation to withdrawal from religious education in Northern Ireland, and I appreciate that that judgment is very specifically about the education system in Northern Ireland. But we nonetheless welcome the Cabinet Secretary's letter, noting that the Scottish Government is confident that the judgment does not impact upon this legislation. Returning to this bill, however, significant concerns were expressed to us about both Part 1 and 2 of the bill. Currently, parents and carers have the legal right to withdraw children from religious observance and religious and moral education. We heard that there is a general impression that the numbers of withdrawals from religious observance and religious and moral education are low. What the committee found, though, is that there is very little information on the numbers of withdrawals, nor is there any information available to us on what children who are withdrawn from religious observance and religious and moral education are doing during the lessons they are withdrawn from. Yes?
John Mason.
I thank the member very much for giving way, and she's linking together the observance and the education, whereas previously there were questions raised about that. Did the committee look at that point? Because it seems to me that all children should be educated, but not all children maybe should be doing observance.
Karen Adam.
Yeah, and I thank the member for that intervention. I will come on to that in my speech, and that was something that did come up, is the difference between religious observance and RME. Yes, I will.
Stephen Kerr.
Can I ask the convener whether the committee had any concerns about the fact that in her earlier statement she said there is little or no data? Why would we be legislating in an area on the basis that there's no data? Did that come up? Was it a consideration of the committee during your proceedings?
Karen Adam.
Well, we didn't doubt that this was happening. There's evidence that this is happening, but I think it's the specific and particular data that we were wanting to see and to know and understand a bit better, and we have asked the Scottish Government to look into providing that data for us. So we've asked the Scottish Government to undertake research to better understand how withdrawal is monitored, and we've also asked the Scottish Government to look at what schools put in place for young people who have been withdrawn. As it stands, if withdrawals continue to be at a low level, then the impact of this bill might be minimal, but its impact must be monitored as greater numbers of withdrawals could have a significant impact on schools. So what were the main concerns about Part 1 of the bill? Firstly, the committee heard concerns about the conflation in the bill between religious observance and religious and moral education. Under the bill, withdrawal from both is treated in the same way. However, witnesses told the committee that they should not be treated equitably. It was suggested that withdrawal should only apply to religious observance. A majority of the committee has agreed with this, recommending that opting out from religious and moral education should not be possible for either young people or their parents and guardians. In an ever more fragmented society, RME seems an increasingly important subject and one from which we consider children should not be withdrawing from. We note that the Scottish Government's reasoning for not adopting this approach, but we urge it to reflect again and bring forward amendments. This approach has been adopted in Wales, and we can't see why it couldn't be adopted here too. We also heard concerns about the potential for familial conflict with this bill that it might precipitate, and we do recognise that there is the potential for conflict under this bill, and we urge the Scottish Government to monitor the impact of the legislation and make sure that schools have the resources and training to meet these challenges. Witnesses also expressed disappointment about the lack of an independent right for the child to opt out of religious observance. The bill provides a right for the child to opt into religious observance and religious and moral education, where a parent has exercised their right to withdraw a pupil, but no right to independently opt out. In that regard, the bill falls short of meeting the concluding observations made by the UN Committee on the Rights of the Child. While we recognise the support for this independent right, a majority of the committee also understood why the Cabinet Secretary had sought to chart a middle ground on this issue, seeking only to make provision for the opt-in. We do, however, still appreciate the strong arguments for this independent right, and a majority of the committee agreed to invite the Cabinet Secretary to consider making provision for this in future legislation. Some of the evidence presented to the committee expressed concern about the absence of a prescribed age at which a child is considered capable of forming a view on withdrawal. It was suggested that this will place undue pressure on teachers to make these decisions on capacity. Others suggested, however, that these kinds of decisions on capacity are ones that teachers are making all the time. A majority of the committee agreed with the approach taken in the bill not to prescribe an age at which a child is considered to have capacity. We do, however, recognise that this will present challenges to teachers. They need to be supported and resourced to make those decisions. I will.
It's Cole Hamilton.
I'm very grateful for Karen Adam giving way. Does she recognise that capacity is actually defined in several different age brackets by various acts of this Parliament? And it's something I've sought to clarify and to bring cohesion on. And is it something that this bill should seek to do as well?
Karen Adam.
I thank the member for that intervention. It's not a committee bill, it's a Scottish Government bill. That was something that we did have great discussion on, though, was that age of the child, of what they could have that capacity. But the majority of us did decide that teachers do deal with these things all the time and have to make those decisions. So another concern presented to the committee about Part 1 of the bill was that it had been drafted as an amendment to existing pre-devolution legislation rather than as a standalone legislation. The result of this is that the bill is not within the scope of the UNCRC Act. A majority of the committee was disappointed by the approach taken. It would have been preferable for the bill to have been drafted as standalone legislation. Stakeholders have recommended amending the bill to bring it within scope of the UNCRC Act. The committee acknowledges that an amendment of this significance might not be admissible, but would nonetheless welcome the Cabinet Secretary's reflections on this concern. Turning to Part 2, the bill amends the UNCRC Act in order to add an exception to the duty on public authorities under Section 6 to act compatibly with the UNCRC, in circumstances where the authority is compelled to act incompatibly in reliance on another Act of the Scottish Parliament. The Scottish Government explained that this is intended to remove the potential for public authorities to have to decide whether to act in a way that puts them in breach of the compatibility duty in the 2024 Act, or to act in a way that puts them in breach of another statutory duty. Stakeholders were both concerned about the implications of Part 2 and perplexed about the rationale for it. It is unclear to the committee why Part 2 is essential at this juncture, given a scoping exercise has not been undertaken to understand whether there is a need for this. We note that the Children's Commissioner has proposed mitigations to Part 2, and we invite the Scottish Government to reflect further on these. The committee is concerned too about the precedent that this approach sets in terms of establishing carve-outs from legislation. Should this legislation be passed, we ask that the Scottish Government ensure Parliament is kept updated about the operation of this provision and how it may be used. As I noted in my opening remarks, after careful consideration, a majority of the committee have agreed to recommend to Parliament that it should agree to the general principles of the bill. It should be recognised that support is predicated on amendments being made to the bill to respond to the concerns I've outlined this afternoon. I look forward to listening to the remainder of this debate and seeking to work towards a bill that can further the rights of children effectively. Thank you.
Thank you. I now call on Miles Briggs. Up to 8 minutes, please.
Thank you very much, Presiding Officer. The Cabinet Secretary opened her comments by saying that this is a finely balanced and sensitive issue, and that government have looked for a middle route. And I think that's clearly where, in some cases, there isn't that middle route. And I think many members speaking today will find it difficult that this bill actually does not deliver that middle route which the Cabinet Secretary is suggesting. But can I start by thanking the Equalities, Human Rights and Civil Justice Committee for their work, and all of those who gave evidence, and the organisations which have all provided very helpful briefings ahead of today's Stage 1 debate as well. From the outset, can I say that I believe it's important for children to have a say in their education, but any change must also respect the crucial role that parents and carers play in shaping their upbringing. And that's something we should never forget. Too often debates don't include the support of our young people, and that's their parents and carers. Scottish Conservatives are concerned that the bill risks creating confusion and conflict, not only within families with unclear safeguards around how... Yes.
Cabinet Secretary.
Thank you, Presiding Officer. I'm interested in Mr Briggs' point on this, because our approach maintains that only parents can initiate a withdrawal from RO or RME. And Mr Briggs also mentioned conflict, and as I think has been observed by Together in their evidence to committee, conflict already exists in the current system. So putting children's rights into law, listening to them, is a simple approach which balances calls from other stakeholders to go further and recognises the role of parents and carers. And I wonder if Mr Briggs would respond to some of those points.
Miles Briggs.
So I don't disagree with some of the points the Cabinet Secretary has made there. The issue is that balance. And, the Cabinet Secretary earlier outlined a system of opt-in, opt-out for young people, that hokey-cokey type system, which has been created. Ultimately, this bill feels like it is flawed and actually not fit for purpose, which is where the committee's work... Yes, happy to take an intervention.
Martin Whitfield.
I'm very grateful for Miles Briggs for taking the intervention. Isn't the challenge that what we're doing is that we're moving the decision-maker for that conflict, that tension between two different groups of human rights, onto teachers in a classroom in a stressed position who are going to have to take a position which they subsequently could be criticised for doing?
Miles Briggs.
I absolutely agree, and I'll be coming on to make more details around that in the rest of my speech, because we are concerned around what impact this will have in our classrooms. And looking at some of the data, and it is a situation that we are making laws without actual data available, but we believe this is already effectively happening in Scotland. If you look at the survey which the Scottish Government undertook in 3 council areas, looking at that figure, it would be understandable that potentially around 4,000 pupils in Scotland are currently being withdrawn from RME and RO without any legislation needing to be put in place. Now, I agree with the points raised by the Church of Scotland in their briefing that the Scottish Government are trying to address this issue and could do better to take forward this case around training and learning and development rather than imposing these duties on teachers. Yes.
Alex Cole-Hamilton.
I'm grateful for Miles Briggs giving way. Does he recognise the concluding observations of the UN Committee on the Rights of the Child, which has repeatedly says that we are out of step with the provisions of the Charter, the Convention, by not legislating to allow children the right to have their voice heard?
Miles Briggs.
So I think what's important is how that can work in practice. And this is where the work of the committee, I think, actually has exposed what that means in practice is often contradictory. And I want to come on, having taken quite a number of interventions, to what this will mean in terms of classrooms. And the Cabinet Secretary, as a former teacher, I do wonder what she's thought about this, if she was back in the classroom, how this would work in practice. And I want to concentrate on the workability of this proposal in the school environment and impacts it will have on the wider school community as well. As Sarah Quinn of the Education Institute of Scotland said, we have significant concerns about the apparent underestimation of the resources that will be required for implementation and about the potential impact on workloads and relationships, and don't feel that this bill fully recognises the policy intentions for pupils' rights either. We've just literally had a question about less contact time. This is putting more duties onto our teachers. Dr Douglas Hutchison of the Association of Directors of Education in Scotland said it's difficult to imagine any straightforward or consistent mechanism to make it work, and that would not be burdensome for the school and onerous on the child and parent relationship as well. And that's where I have concerns around what this will also mean for those children who will be potentially withdrawn from these lessons. There is a concern, and I note from the committee report around this as well, of isolation of young people in our schools, and the model which would be delivered also not being touched upon are care experienced young people and the decision making around these individuals. I don't know if that's been overlooked by the Scottish Government, or where actually we haven't looked at a very important group of people as part of the promise, and those decision making in school as well. Presiding officer, I studied religious education when I was at school, higher religious education, and as the convener has stated, I think it's very important that we actually make the case for greater understanding of different faiths and beliefs, and that through learning and experiences in our schools, we actually try to break down the barriers which often debates in this chamber look towards, that we increasingly are living in a diverse and multicultural society, and in a world where global connections and communications are deeply entrenched, we need to understand each other's and our religions. And so I do express concern that this creates a situation where some young people could go through the education without having that opportunity to understand other religions and faiths. To conclude, Presiding Officer, I'd like to thank my colleagues, Tess White and Pam Gozal, for their work on the committee. They were consistent in their questioning and raising concerns around the evidence sessions in the committee. And it is important, as I opened my comments, that we do look towards children having a say in their education, but any change must also respect that crucial role parents and carers are helping to shape their upbringing. We are concerned that the bill risks creating confusion and conflict within families, with unclear safeguards around how parental rights and children's views would be balanced in practice, while placing significant burdens on our schools and teaching staff. Presiding Officer, rights must be workable in practice, and many education professionals, from teachers to directors of education, have warned that this bill is unclear, burdensome and risks creating conflict. This can't come at a cost of damaging relationships at home or overwhelming our schools, who already are complaining of too much bureaucracy within their walls. So given the uncertainties and the potential impact on families and teaching staff, Scottish Conservatives will not support the bill at stage 1 and will look towards stage 2 to bring forward amendments. Thank you.
Thank you. And I now call on Martin Whitfield, up to 7 minutes, please.
I'm very grateful, Presiding Officer, and I remind the Chamber of my note of interest from the beginning of this session. And I rise, and it's a pleasure to speak at this stage 1 debate on the Children Withdrawal from Religious Education Amendment of UNCRC Compatibility Duty Scotland Bill, a very impressive title. The bill seeks to do two things, and the first is to involve pupils in the decisions about withdrawal from both religious observance and religious and moral education, but also second, to amend the UNCRC Incorporation Act to clarify circumstances where incompatible actions by public authorities are not unlawful. In other words, where a public authority is breaching a child's human rights. Now, on the face of it, these aims may sound reasonable, but the detail of the bill and the evidence presented to the Equalities, Human Rights and Civil Justice Committee, and can I thank them and the convener for their excellent work on this and those that gave evidence, reveals very serious challenges that will make it impossible for us today to support the general principles. Part 1 addresses withdrawal from religious observance and RME. The intention to give a children's voice when parents seek to withdraw them is welcome in principle, but the challenge is that the bill fails to distinguish that deeper problem, that continued right to withdraw from RME in non-denominational schools. RME is not a confessional period. It is an academically rigorous subject that helps young people understand not just world religions, not just their own religion, but ethical issues, philosophical perspectives, skills essential for life in a diverse Scotland. And yet, by maintaining a statutory right to withdraw from RME, the bill perpetuates an outdated approach that denies children access to a full curriculum. Almost everybody that gave evidence to the committee, including STARMI, faith representatives, humanist organisations, recommended removing this right to withdraw from RME, and the committee's majority agreed. Continuing the right contradicts the spirit of the UNCRC and undermines the entitlement to a broad education. But the bill also conflates religious observance and religious and moral education, despite their fundamental different purposes, one reflective, one educational. And this conflation is a historic anomaly that legislation should have covered. And if we look to part 2, Deputy Presiding Officer, if we look at the policy document, the assurance from the Scottish Government was that they were committed to upholding the rule of law by ensuring that laws are clear, accessible and effective. It also committed to fully realising the human rights of all people in Scotland, including complying with international human rights obligations. I start here because Part 2 is presented as a technical fix providing a legal clarity. But let's be clear, it introduces a significant risk to the integrity of the UNCRC incorporation here in Scotland. The Act was designed to create a proactive culture of accountability for children's rights. Section 6 imposes a duty on public authorities to act compatibly with those rights. But Section 2 carves out an exemption to that duty and allows public authorities to act incompatibly when compelled to do so by Scottish legislation. This has been described as a pragmatic solution, but in practice it's creating blind spots. It means that when a child's rights are breached because of a statutory requirement, that breach cannot be challenged under the UNCRC Act. The accountability mechanism shifts from the courts and into legislature, but with no guarantee that incompatibilities will be identified or addressed. And if we go back to the Deputy First Minister's comments in 2019, John Swinney said, "The key point to observe is that the purpose of incorporating the UN Convention on the Rights of the Child into Scots law is to provide the highest level of protection for the rights of children in our society. If that requires Parliament to amend the existing legislation of Scotland to ensure that it is compatible with the UNCRC, that is precisely what Parliament has to do." The bill does the opposite. Instead of amending legislation to make it compatible, which was suggested by the committee, it creates an exemption that allows incompatibility to persist. There is no statutory duty for public bodies to report when they rely on this exemption. There is no audit of existing legislation that conflict for at least a year. In short, we risk embedding a loophole that will weaken the very protections that the UNCRC Act was meant to deliver. Give way.
Martin Whitfield actually underpinning the point in his description of Section 2, that there is no place in that for the rights and responsibilities of parents. What role does he see the rights and responsibilities of parents over their children playing in this at all?
Martin Whitfield, I'll give you the time back.
I'm very grateful. It is right to say that parents have the human right to parent. They have a responsibility for education, and much of that sits in Part 1. The reason that I'm concentrating at this stage, as I hope the member will appreciate with regard to Part 2, is because of the coach and horses it potentially drives through protections that we have there. Protections that, in this case, relate to young people because of the definitions within the UNCRC, but also perhaps speak to an attitude towards human rights that appears to be developing that is incredibly dangerous, and that is they're fine when they're fine, but if they cause us a problem, let's find a way to ignore them. And that worries me. This bill has the potential to restrict... I will, if it...
I'll be very brief. I'm grateful to the member for giving way. Does he recognise, as I do, that this catch-all application in Part 2 does fatally undermine our attempts to successfully incorporate the UNCRC? And should there ever be legislation where there was a need to disapply it, we could just make it specific to that legislation?
Martin Whitfield.
I fear and concern a period of time where the situation is such that we have to so explicitly disapply human rights. But I agree with the substance, certainly, of the intervention. This Scottish Government wants to remove the rights of our children when they're compelled to by Scottish legislation. There is no potential end to that tunnel. I know the Cabinet Secretary said she can imagine it only ever being used once. My greatest fear is that as soon as a vehicle is discovered that successfully moves to one side the ability of an individual, in this case young person, to bring a claim under the UNCRC, but have to rely on bringing down an entire piece of legislation with regards to their rights, that will prove very attractive going forward in some circumstances, and I am not prepared to endorse that message. Stage 1 report from the committee, and again I thank them for their work, supports the principle of giving a child a voice, but only with substantial amendments. It expresses disappointment that the bill excludes itself from the scope of the UNCRC. It warns the benefits of the bill may not outweigh the negatives if drafted stands. In short, this bill is not ready. It does not deliver the rights-based approach Scotland is committed to. It does not reflect the weight of the evidence on RME, and it does not provide sufficient safeguards with regard to Part 2. And so for this reason, when it comes to the general principles, we will be abstaining. I cannot oppose them to go back to the memorandum because the Scottish Government's stated intention was to strengthen children's rights. This bill does not do that, but it could be the vehicle to do that, and therefore we will be abstaining. Deputy Presiding Officer, this Parliament has a proud record of advancing children's rights, even in the face of a Scottish Government retreating from that record. This Parliament must ensure that its reputation, its responsibility, is not compromised by legislation that falls short of our own ambition. I'm grateful.
Thank you. I now call Maggie Chapman up to 6 minutes. Ms Chapman.
Thank you, Presiding Officer. This Parliament has taken significant strides in promoting children's rights. After 3 years of delay caused by a petty UK government, last year we enshrined the UN Convention on the Rights of the Child into Scots law. Previously, my Green colleague, John Finney, ensured that all children are protected from physical assault under the guise of so-called discipline, even from their parents. Yet we have so much further to go. Our age of criminal responsibility is just 12. Higher than other parts of the world, but lower than many countries, lower than the UN Committee on the Rights of the Child recommended age of 16, and even lower than its absolute minimum of 14. This bill before us concerns another area where children's rights are not fully respected. The child-facing version of UNCRC says, "I have the right to be listened to and taken seriously." But the 1980 Education Act allows children to be withdrawn from religious activities in schools without their consent and without even taking their views into account. That is clearly contrary to the Convention, and I welcome this opportunity to correct that. But the bill, as drafted, suggests that the Scottish Government's determination to ensure rights compatibility only goes so far. It allows a young person to opt back in if they have been opted out of those activities, but not to opt out themselves. This directly contradicts the Scottish Government's own draft child's rights scheme, which says it wants to, and I quote, "give children the knowledge and confidence to use their rights." That suggests, rightly, that children should be able to use their rights proactively, not only after an adult has acted on their behalf. It also contradicts the Children and Young People's Commissioner Scotland. In her letter to committee, she was explicit. I quote, "Part 1 in its current form does not achieve compliance with UNCRC." And the Commissioner is far from alone. The committee's Stage 1 report also notes that a majority supported amending the bill to provide children with an independent right to withdraw from religious observance. That majority includes the Scottish Human Rights Commission, UNICEF and, together, the Scottish Alliance for Children's Rights. Professor Angela O'Hagan of the SHRC told committee that, without such a right, the bill will fail to meet its basic aim of achieving compliance with UNCRC. I found myself in a minority of one when committee reported on this aspect. But if colleagues remain opposed to this amendment, I ask them to reflect why they think they know better than every children's rights organisation in the country, and better than the public and their own supporters. Because the Survation poll released today by the Humanist Society Scotland shows that 66% of Scots believe pupils should be able to decide for themselves whether to take part in religious observance. Majorities of supporters of every political party agree. It's also doubtful whether the provisions of the 1980 Act would withstand legal scrutiny, regardless of this bill. Just last week, judges ruled that collective worship in Northern Ireland, which isn't objective, critical and pluralistic, amounts to indoctrination and is unlawful. The Scottish Government has responded to this, but they've also been warned that a similar challenge could succeed here unless this bill is amended to uphold young people's rights. This bill also suffers from another major flaw. Like the 1980 Act, it conflates religious observance with religious education. Religious observance, acts of worship, especially when one faith is prioritised over another, should have no place in state schools. Young people of different faiths or of no faith should not be forced to take part in worship. Forced observance is incompatible with Article 14 of UNCRC, which says, "I have the right to have my own thoughts and beliefs and to choose my religion." Yes.
John Mason, briefly.
On that point, is the choice, say, for a Catholic school, not that the parents and the child choose to go to the school and therefore take part in religious observance, rather than later on down the road?
Maggie Chapman.
I think while we have religious state schools, then those beliefs of that school need to be taken account by the parents in choosing that school. I think what many of us would rather is that we have complete separation of church and state in our education system. The Children's Commissioner is clear that this includes freedom of religion, thought and conscience, freedoms the current system does not adequately protect. Religious education, or RME, however, is quite different. As we've heard already this afternoon, learning about diverse religions and belief systems is an essential part of a broad education in a pluralist society. Young people cannot withdraw from science, maths, history or English for good reason. Religious and moral education is similarly vital. And teachers agree. Dr. Douglas Hutchison of ADES said, "RME should be seen as a curricular subject in the same way as any other. The idea that in a liberal democracy there is no place for religious education and there should be a right to withdraw from it does not make sense in 2025. The Scottish Episcopal Church told committee, "RME stands firmly within the school curriculum. Our children need to understand other faiths, beliefs and cultures if they are to grow up in the diverse, inclusive and tolerant society we want in Scotland. There is a big distinction between RME and RO, and the bill does not recognise it." The Church of Scotland and other faith groups also share this view. I will speak to part 2 later this afternoon, so to close for now, Presiding Officer, I welcome this bill in part as an opportunity to strengthen children's rights, but it clearly does not go far enough to ensure that young people's views are heard, respected and acted upon. It risks entrenching the idea that children's rights are to be exercised only after adults intervene, rather than independently and proactively. And it risks undermining the vital role of RME by failing to separate it clearly from religious observance. I will bring amendments to separate RO and RME and to introduce the independent right of a child to withdraw from RO at stage 2. Thank you.
Thank you. I now call Cole Hamilton up to 6 minutes. Mr Cole Hamilton.
Thank you very much, Presiding Officer. Presiding Officer, the Liberal Democrats, as I expressed to the Cabinet Secretary, will support the general principles of this bill, but it is a finely balanced support because we will do so as it represents the last opportunity to extend children's rights in this Parliament. But this is very much a curate's egg of legislation, good in parts, but there are massive deficiencies, and I agree with much of what's been said in critique of that so far. Presiding Officer, as you know, before politics I was a youth worker. Fighting for the rights and well-being of children is in my political and spiritual DNA. And the bill before us presents us again with that question we keep coming back to in this Parliament, is do we believe children and their rights should be taken seriously and that they should have a voice in the decisions that shape their lives? It is my belief, it is the belief of my party, and it is the settled will of this Parliament that they should. We have legislation that incorporates the UNCRC into Scots law, and yet concluding observation after concluding observation of the Committee on the Rights of the Child, which is the guarantors of that convention, have concluded that Scotland is out of step with the intent of the convention on these issues. Part 1 goes some way. Of course I'll give
Stephen Kerr.
Very clearly, Alec Cole Hamilton say he believes in the rights of a child. But what about the rights of parents As you will have probably noticed, this is a theme of my contributions this afternoon. We're talking a lot about the rights of children, but what about the rights of their parents in terms of their legal duty of care for their children?
Alex Cole-Hamilton.
Both have rights, and neither of them should be mutually exclusive. But Stephen Coe will recognise that at the age of 12, if you need to consent to a medical procedure, you do so without your whatever, irrespective of your parents' views. That needs to come from the children. We already disaggregate those decision-making powers, and rightly so. Presiding Officer, Part 1 goes some way to addressing the deficiencies in our policy that the UN Committee have identified. And when a parent withdraws a child from religious observance or RME, the school must inform the child, give them space to express their views, engage with the parent and child where disagreement arises, and then ultimately respect the child's wishes where they have capacity. I agree this doesn't go far enough, and it is confusing to conflate the two in terms of religious observance and RME. I think that should be disaggregated. And Article 12 of the UNCRC is one of the most fundamental pillars of that convention. The child has a right to express a view in all matters affecting them, and for that view to be given due weight according to their age and maturity. Now, I need to clarify my intervention on the committee convener. I don't think I expressed myself well there, but this Article 12 is elegant in its simplicity. It doesn't define the age of maturity, and nor should it, because that is a judgment call. And I think on sensitive issues like this, in discussion with both parents and children, a view can be arrived at. But the views of the child should never be discounted if they can be delivered and articulated. And together, the Scottish Alliance for Children's Rights, it was an organisation I was very proud to be convener of, is clear that when decisions profoundly affect a child's values or their outlook or their worldview, their voice must be heard. They want to see the bill go further in that regard. In their view, I quote, with the right amendments at stage 2, this legislation could mark another important step towards the full incorporation of UNCRC into Scots law. And I support some of the amendments that Maggie Chapman has articulated in that regard, because it's not just about I think we need to allow for children themselves to withdraw from religious observance. So while John Mason said that if a family intends to situate a child in a Roman Catholic school, that's clearly a statement of intent, and that's what they should expect. Well, religious observance doesn't just stop and end at Catholic education. It does happen in all aspects of life, particularly presiding officer at this time of year as we approach the Christmas season. It's clear that this bill does need work, significant work at stage 2. And the committee heard legitimate concerns, as I've said, about the conflation of religious observance and RME and the potential conflict within families and how we assess that capacity. In my view, they do need looked at. I'll now turn to Part 2, and I raised something of this in my concerns with the Cabinet Secretary, which seeks that new exemption and the compatibility duty. This would allow public authorities to act in ways that would otherwise be incompatible with children's rights when compelled to do so by provisions in acts of the Scottish Parliament. That is effectively a release valve, a get-out clause, a backdoor to allow local authorities the means of not observing the rights that we have asked them to observe in respect of children and young people. In effect, it limits the legal obligation on authorities to uphold UNCRC standards in specific circumstances underpinned by Scottish law. The Equalities, Human Rights and Civil Justice Committee has raised concerns about this part of the bill, including the government's failure to make a robust case of the need for it. I don't think I heard that in the remarks of the Cabinet Secretary. I'm glad she is closing for the government as well. If I have time, I'll certainly take an intervention from Martin Whitfield.
Very grateful to Alex Cole-Hamilton taking the intervention, but yet the Cabinet Secretary has certified under Section 23(1) of the UNCRC in the policy papers that this bill complies with the UNCRC. Does the member struggle, as I do, to see that contradiction that appears to exist with Part 2?
Alex Cole-Hamilton, give you the time back.
I'm very grateful to Martin Whitfield for his intervention, and actually he makes the point I was coming on to make entirely, is that this is not, I can't see how effectively giving you an opt-out from the UNCRC legislation we as this Parliament have passed is in any way compatible with that same legislation. It almost disapplies it at the most simplistic analysis of it. So I'm grateful to him for that. I agree with the committees that it's not clear why these changes are needed or what problem they are intended to solve, and this has been introduced with little clarity about its long-term implications that also I think, threatens the support of many parties, several parties in the chamber, who are proceeding in good faith, who want to see the furtherance of children's rights in the parliamentary time that we have remaining. There's also concern about the precedent it sets in looking for those carve-outs and what implications that might have for future Scottish human rights bill that we've heard talked of for the next Parliament. Presiding Officer, I'm concerned that this risks weakening the architecture, the very architecture of the incorporation of the rights of the child. A range of human rights organisations, including the Children's and Young People's Commissioner, are aligned on this point and express their concerns, as we have heard several times today in their Stage 1 evidence. Liberal Democrats will continue to champion children's rights. We will move forward in good faith on this bill, but our patience is finite. And until the government can tell us why Part 2 is needed, then we can't see it towards Stage 3 in the final analysis of this bill. Thank you.
Thank you. We now move to the open debate. I call first Paul McLennan to be followed by Pam Gosal, around 6 minutes. Mr McLennan.
Thank you, Presiding Officer. Can I thank Cameron Adam for her opening speech? As convener of the committee, as a member of the committee, evidence sessions were extensive, and I think we've heard today there were different opinions within that. The bill gathered lots of differing opinions, as I said, and was a motive to many. Striking a balance on legislation, of course, is key. The committee was split on the benefits of young people on the bill. I, like the majority of the committee, supported the general principles, but obviously with the needs for amendments. Stakeholder engagement was wide as we discussed the bill, and can I thank them all for their participation. As a person of faith, I am very much in favour of ecumenical teachings in schools of all faiths. Understanding and respecting each other's views is so important, be that of faith or of none, as we push back against prejudice and ignorance. Religious observance and our own religious and moral education, RME, are of course important in their own right, and I'll touch on that later on. It's important to understand the context of the bill, and of course one of the key things was on the level of withdrawals. And I remember one of the first questions committee was asking about the numbers that were impacting that. Now, of course, there is limited information on that, and I'd like to see how that can be improved. The numbers were small, but I think what's important is just to recognise, even if they are small, it's important that 1, 2 or 3 people, regardless of what how small the numbers are. On the more general point, the committee has asked the Scottish Government to consider how best it's aware of how Arrow is delivered and the numbers requesting withdrawal. And I think that's really important to keep the context in terms of what we're talking about. Conflation, as it's been mentioned before, between RO and RME was, of course, a very important topic. And as I stated before, the importance of RME is increasingly more relevant, and I would agree with the Majority Committee that RME should not be a topic that children can withdraw from. RME, of course, is one of the 8 curriculum areas in the Curriculum for Excellence, and I understand the point that others have made around about if they can withdraw from there, what other issues can they withdraw from? And I remember how much my own 2 kids valued RME at the school, and how much it informed them in respecting others at school and even now in terms of going forward. So that's really important in terms of that. Now, I note the Cabinet Secretary has stated she will give careful consideration to this topic in advance of Stage 2. In the bill, the committee recognised that there is potential between parents and children, and I think that's, again, where there has to be the key balance in terms of that, and I acknowledge the point that Stephen Kerr made on that, and again I'll touch on that later on. The intention of the bill is, of course, increasing rights for children. Resource for schools to be able to deal with the conflict is important, and that was raised with some of the schools we discussed with in the evidence session. The Cabinet Secretary has obviously advised that the bill includes a requirement to seek discussion between parents, children and the school. Cabinet Secretary also stated in a response to the committee that this gives a legal right under Article 12, the UNCRC, the right to be heard, Article 14, the right of freedom of thought, conscience and, of course, religion, and Article 29, the purposes of education. The issue of the right of the child to independently opt out of an RME was also a topic of conversation. I was encouraged to hear the Cabinet Secretary wish to chart a middle ground on the issue. And again, I'm cognizant of what's been said on that particular view. The majority of the committee considered it would be more appropriate this time for the right of children to object from RO and RME alone. On the issue of child's capacity to form a view, this was discussed in the committee and stakeholders. And I think the point that made you could have a very mature 12-year-old or an immature 14-year-old. So I think the majority of the committee agreed that the bill should not specify an age threshold when a pupil's views are considered in discussions about withdrawal from RO and RME, and I think that's the correct way to go down. The committee mentioned about the need for support and training on this issue in the decision-making capacity of pupils. And again, a few schools actually touched on that, whether they were dominational schools or non-faith schools in terms of that. And I think the training issue is a really important point, and I hope the Cabinet Secretary can pick up on that point in our summing up. As we've heard, one of the key issues all the way through this was compatibility with the UNCRC. And of course, this was an issue for stakeholders, particularly the session panel we had with those with legal expertise. Now, I'm aware of the position of the Cabinet Secretary regarding the 1980 Education Scotland Act in terms of that. I want to move on now to Part 2 of the bill. The committee recognised concerns about Part 2 of the bill, the rationale, the precedent and whether the bill is an appropriate vehicle. I note comments from the Cabinet Secretary in response that this is a necessary and proportionate safeguard to ensure that UNCRC Act operates reliably as case law develops. Together, as been mentioned, HHRC and the Children's Commissioner have all offered support for the bill, although that is caveated. The committee, of course, has asked that the Scottish Government ensures that the Parliament is kept updated in reference to Part 2 of the bill. Presiding Officer, in moving to the general principle of the bill, there was no doubt there was concerns presented to the committee, and we've heard members today on different opinions to that. It was encouraging to see in response to the Stage 1 committee report that the Cabinet Secretary would consider some of the points raised by stakeholders as we move towards Stage 2. In our closing paragraph to the Stage 1 committee report, the Cabinet Secretary notes the significant concerns highlighted by the committee and stakeholders, and she will reflect carefully on the points made as the bill progresses. I look forward to future discussions on the bill with her and other stakeholders. Thank you.
Thank you. I now call Pam Gosal, followed by Eleanor Whittam. Up to 6 minutes, please, Ms Gosal.
Thank you, Presiding Officer. Before I begin, I would like to thank the Equalities, Human Rights and Civil Justice Committee for producing its Stage 1 report into the Children Withdrawal from Religious Education Amendment of UNCRC Compatibility Duty Scotland Bill, as well as all the witnesses that provided evidence to the committee. I am pleased to speak on behalf of the Scottish Conservatives on this very important debate, but also as a member of the Equalities, Human Rights and Civil Justice Committee. This bill, which would require schools to inform a child if their parents ask them to be withdrawn from religious education and/or observance. It also gives the child a chance to express their views, and in cases where the child's views are different from those of their parents, the school would have to follow the child's wishes. Presiding Officer, whilst I recognise the good intentions of the Cabinet Secretary in introducing this bill, however, in today's speech, I would like to lay out my concerns. These include the conflict the bill puts on rights of parents and the views of children, the impact on families and teachers, the reality that children develop at different stages. Let me explain some things about this bill. Firstly, the bill... I've just started, can I move on, but on you go.
Alex Cole-Hamilton, briefly.
I'm grateful to Pam Gosal for taking an intervention. I'm interested in her choice of language about the conflict that she sees exists between the rights of parents and the views of children. Does she recognise that children have rights as well?
Pam Gosal, I'll give you the time back.
Thank you. Absolutely. I do recognise that children have rights, but you also need to understand where the parents fit in here. They are their legal guardians and their caretakers, and you need to listen to parents, because you'll see later on how I talk about the fear of precedents being set. So I hope the member understands. Whilst I understand that there are rights for children, there's rights for parents, but there has to be a balance. Let me explain some things about this bill. Firstly, the bill risks stripping parents of their rights. While it is important that the voices of children are heard, we must remember that parents are their primary guardians. Children under the age of 18 are not old enough to purchase and consume alcohol, be liable for council tax, get a credit card and much more. But hold on, they are old enough to override their parents. Another issue of concern is what precedent does this bill set. We may be talking about religious education and observance now, but what comes tomorrow? For example, would a child be able to override its parents when it comes to education on controversial issues such as LGBT or gender ideology? Already, many primary schools, including in my area of East Dunbartonshire, are working with controversial organisations such as LGBT Youth Scotland. This is an organisation which is not geared towards children of primary school age. I have been contacted by many concerned parents asking me for help, as they believe such organisations should not have any involvement with their children. Therefore, a bill which would let children override their parents' risks, opening a new can of worms by bringing in dangerous ideologies from the back door which serve a political agenda and go against parents' rights. This bill also risks becoming a repetition of the so-called named persons scheme fiasco from the SNP and its then Cabinet Secretary for Education, John Sweeney, had to shamefully walk back from. There are also extreme worries when it comes to determining whether a child is mature enough to override its parents. Who is to tell one child is capable of forming a view, but another is not? This puts the teachers in a very difficult place, potentially creating conflicts between pupils, but also between teachers and parents. Teachers already face excessive burdens in our schools, including but not limited to excessive workload, challenging pupil behaviour and ever-increasing incidents of violence. The last thing they need is the administrative burden of having to determine whether children can override its parents when it comes to religious education and observance. And of course, this bill risks isolating children. Allowing teachers to make a choice on this issue would lead to a lot of inconsistency, and emotional impact on children should be recognised. In their written submission, the Catholic Head Teachers Association of Primary Schools wrote, "There is a very real risk that the proposed changes to the bill could result in primary-age children being isolated from their school community." Presiding Officer, Scotland's children's rights legislative landscape is already complicated, and this approach adds even more complexity. As part of the Equalities Committee, we heard from several witnesses who worried that the bill is a temporary and short-term solution that does not address underlying issues. I remember Angela O'Hagan from the Scottish Human Rights Commission saying that we are looking at another legislative instrument added as a sticking plaster to patch up legislation whose proposals have not been well defined in the first instance. At the same time, Fraser Sutherland from the Humanist Society Scotland said that the bill documentation and pre-bill consultation clearly show that the government does not fully understand what is happening. If this government's legislation is flawed, only a short-term fix, then what was the point of introducing it in the first place? In closing, Presiding Officer, we are tasked with creating good legislation, and the committee have a duty to scrutinise. Unfortunately, this legislation is not up to the standards of this Parliament. We cannot be complacent here, especially when some might try to hijack this bill to bring in dangerous ideologies which open the back door to the political agenda which erodes parental rights. I would like to make it very clear that, for the reasons I have stated today in this speech, I will not be supporting this bill.
Thank you. I now call Lena Whittam to be followed by Pam Duncan-Glancy. Around 6 minutes, please.
Presiding Officer, let me begin by expressing my appreciation to the committee for the depth and care shown in its Stage 1 scrutiny of this bill, and to all stakeholders who gave evidence. Today I speak to offer tentative support for the bill. My support is rooted in my long-held humanist values, values that centre the rights, dignity and evolving capacities of children and young people, and in a desire to see Scotland continue to embed human rights in everyday practice. The bill is seeking to bring our education system closer to the principles of the United Nations Convention on the Rights of the Child. For the first time, schools would be legally required to inform a child when a parent requests their withdrawal from religious observance or religious and moral education. And crucially, that child must be given the chance to express their own views. Where young persons' wishes differ from those of their parents, schools must seek to understand and respect the child's perspective. Now, I was opted out of RO as a child in a Catholic school setting, and I opted my children out of RO. But I fundamentally believe that my children should have the right to challenge me. And indeed, if I was to seek to withdraw my child from sexual health education, I hope that I've raised my children with the capacity to challenge me in that respect as well. From a humanist standpoint, this matters immensely. It recognises children not merely as passengers in their own educational journey, but as rights holders, individuals capable of forming and expressing their own beliefs. The Government's own assessments acknowledge that this strengthens Articles 12 and 14 of the UNCRC, the rights to be heard and the freedom of thought, conscience and religions. And these are welcome steps forward. The bill also attempts to resolve a long-standing tension within the UNCRC Act by creating a narrow exception for public authorities caught between conflicting legal duties. Now, I do understand why the Government feels that this is necessary. Our schools and public bodies should never be placed in an impossible legal position, and this bill is aiming to provide clarity. However, and this is where my support remains cautious, the committee heard compelling evidence that the bill does not yet fully realise the rights that it is seeking to protect. The Scottish Human Rights Commission, the National Secular Society and Humanist Society Scotland, for example, made a particularly powerful case that the bill does not provide children with the independent right to withdraw from religious observance. Only children whose parents initiate withdrawal are given any voice at all. And that falls short of the UN Committee's recommendations. As things stand in the bill, a child whose parents have opted them out of religious observance is empowered, once sufficiently mature, to opt themselves back in. Yet a child whose parents do not opt them out has no equivalent right to opt out on their own. That is a fundamental asymmetry, creating a hierarchy of rights that I believe is wholly contrary to the UNCRC's emphasis on the child as a rights holder in their own capacity and not merely as an extension of parental belief. The committee also had concerns about access to justice. By carving out exceptions in the UNCRC Act, the bill risks weakening the framework that was expressly designed to help children challenge rights breaches. Yes?
Martin Whitfield.
I'm very grateful to Lena Whittam take the intervention, and I think she encompasses in a most articulate way the real challenge of what giving local authorities an exemption outside of UNCRC causes, where we have an individual child who potentially has to enforce their human rights by saying, I can't opt myself out. But to do that, if this bill passes, they have to go all the way to Europe, because they have to challenge the legislation and they will need support to do that. Whereas without this opt-out, they could, once we know what the domestic procedure is, perhaps deal with this locally far more civilly and retaining the relationships they need for good schooling.
Eleanor Whittam, I can give you that time
Thank you, Presiding Officer. I do recognise the argument that Martin Whitfield is putting forward. The Commission warned that without safeguards such as requiring public authorities to notify Scottish ministers when relying on that exception, we risk creating a lack of transparency and undermining accountability. And I have to say those concerns struck me as both reasonable and serious. And human rights organisations contend that without addressing them, the bill will not fully comply with the UNCRC. And it's also worth drawing attention, as has been done previously by Maggie Chapman, to the polling out today commissioned by the Humanist Society Scotland that shows that 66% of the population support a young person's right to withdraw independently. Another issue raised repeatedly was the lack of clarity created by treating religious observance and religious and moral education as though they were interchangeable, and we've heard a lot of that already today. As the Children and Young People's Commissioner reminded us, these are very different activities with different purposes and therefore different rights and implications. Blurring that distinction does not help pupils, parents or teachers. It only adds to confusion, and I think it could undermine community cohesion, and none of us wants that to happen. All of this takes place against the backdrop of last week's Supreme Court ruling in Northern Ireland, which found that a predominantly confessional approach to religious education, even when accompanied by the right to withdrawal, was incompatible with human rights standards. And that ruling is a stark reminder that relying on withdrawal alone is not enough. Education must be objective, critical and pluralistic from the outset. From someone with a humanist worldview, the significance of that decision cannot be overstated. It aligns with what many of our stakeholders have been telling us for years, and in the context of Scotland, issues that have been laid bare in the Humanist Society Scotland's recent report, Preaching is Not Teaching. Presiding Officer, I want Scotland to be a place where every young person, whether they come from a faith tradition or no faith at all, feels equally respected in their school environment. A place where their conscience, their curiosity and their developing sense of identity are nurtured rather than constrained. So whilst I am willing to support the general principles of the bill at this stage, my support comes with a clear expectation that the Government will take seriously the evidence offered in the committee's report. We must strengthen children's agency. We must ensure transparency and guard their access to justice. And we must clearly distinguish religious observance from religious and moral education so that rights and expectations are clearly understood. If the Government addresses these issues, and I sincerely hope that it will, then this bill has the potential to move Scotland meaningfully closer to the rights-respecting, pluralistic education system, one in which every child, no matter their belief or background, is truly seen, heard and respected. Thank you.
Thank you. I now call Pam Duncan-Glancy to be followed by Marie McNair. Up to 6 minutes, please. Ms Duncan-Glancy.
Thank you, Presiding Officer. Forgive me for 2 seconds to get my notes. Thank you, Presiding Officer. I'd like to start by thanking the Equalities, Human Rights and Civil Justice Committee for their scrutiny of the principles and basis for the bill. Reading through the committee report and having listened to contributions, it's clear that the committee covered a lot of ground in preparing for the bill to be debated today. Committee has identified areas, as have members across the chamber, that I agree should be explored further before my party or I can comprehensively consider supporting the bill. The report shows gaps in the foundations to the bill which should really have been filled before this Parliament was asked to draw conclusions. I think it's worth saying at this point that the fact that the Government outline in the response to the bill that this is their third attempt at making changes in accordance with the UNCRC shows that yet again they are legislating in panic mode, and I don't think that is any way to address such fundamental issues as children's rights. The committee and witnesses all outlined concern on the foundations on which this bill comes. The lack of data on the number of withdrawals and what schools put in place for such withdrawals, the burden on schools and a child's capacity to form a view, and the conflation of religious observance and religious and moral education. Committee has, of course, identified other gaps, and I'd encourage anyone who hasn't had a chance to read the report to refer to it to get a picture of the concerns and some flaws within the bill. The committee recommended that the Scottish Government undertake research to understand how withdrawals are monitored. This data, I believe, is key to members' decision on this bill as it moves through Parliament and should really have been available ahead of time. The gathering of the information is patchy at best and could not be called consistent across the country in any way. Without these key statistics gathered in a way in which they can be accurately compared and contrasted, I believe it will be very difficult, if not near impossible, to assess the impact of this legislation on schools' capacity to deliver the intention of it. As a Parliament, Presiding Officer, we have a responsibility to legislate in practice, not in theory. This means thinking about what legislation looks like when it leaves this chamber, when it touches reality, and what impact it will have, both intentional and unintentional, on the people primarily affected by it. In this case, children, their parents, teachers and, as they are referred to in the report, the operator of the school. The committee report refers to the school as the body who will be asked to evaluate whether or not a child has the capacity to form a view. In practice, this means people who we know are really hard-pressed already, teachers, school administrators and school leadership, will have to be making difficult decisions on a new area. And in this respect, I agree with several respondents who spoke of what they termed the burden that this legislation could place on schools. As a Parliament, we must match ambition with resources. Teachers watching this debate today, many of whom are already shouldering more responsibility than they have contracted hours in the day for, would want me to press the Cabinet Secretary on whether she believes the financial memorandum would benefit from more relevant and comprehensive data to inform its projections and indeed workforce planning in this respect going forward. The memorandum itself states that there is no available evidence to inform an estimate of how often these disagreements will take place, meaning that right now it's impossible for the Government to quantify the amount of staff resource, time and energy needed to ensure the legislation would be enacted. Without understanding this, I believe it's impossible for us as members to appreciate both what the burden could look like and what will be needed to mitigate it. Whilst we can't gather data on something that doesn't yet exist, we can gather data, better data, on withdrawals as they stand now, so that we can better understand the extent of the demand that will be placed on school administrations. Respondents also raised concern that the bill doesn't distinguish between religious observance and religious and moral education. despite being very different. RME, as has been said already, is part of our curriculum and of children and young people's education. It encourages pupils to learn about different beliefs, to open their minds to different views and to consider what they themselves believe. In this, it is a key pillar of the government's own education framework. Religious observance is, I think we can all agree, different. Scottish Labour supports faith schools and parents' right to make decisions about their children's education and respecting the importance of involving children in the decisions, and we understand the wish for legislation to address the issue. But due to the significant problems with the drafting of the bill, the lack of existing data, the pressure on already overstretched schools, the lack of consideration by government so far of how it will support and resource them to implement it, and the lack of delineation between observance and education, regrettably, I and my fellow Scottish Labour members will not be able to offer our full support to this bill at stage 1. Thank you, Presiding Officer.
Thank you, Ms Duncan-Glassie. And I call Marie McNair to be followed by Rose McCall. Up to 6 minutes, please.
Thank you, Presiding Officer. As a member of the Equalities, Human Rights and Civil Justice Committee, I welcome the opportunity to speak in this debate. Can I thank the clerks for their assistance in drafting this Stage 1 report? And I'm also grateful to all stakeholders and witnesses for taking the time to submit their views on this issue and for their helpful briefings. As mentioned, the bill has two main objectives. One, to require schools to consider pupils' views when parents withdraw them from religious observance and religious and moral education. And secondly, to amend the United Nations Convention on the Rights of the Child Incorporation Scotland Act 2024, so that public authorities are not conflicted between complying with the Act and other Scottish legislative duties. To give some context, currently the Section 9 of the Education Scotland Act 1980 gives parents a right to withdraw their child from both religious observance and religious and moral education in schools. The purpose then of this bill is to give greater autonomy to young people, and where a parent has made a request to withdraw a pupil from instruction in religious observance or religious and moral education. When this occurs, the school must inform the pupil about the request and consider the pupil's view as part of the withdrawal process. I will firstly touch on Part 1 of the bill, which focuses on withdrawal from religious observance and religious and moral education in schools. On this point, we received helpful evidence from many different stakeholders, and from this, the committee is of the view that religious observance and religious moral education should be separated in this bill. This is because most of the committee agreed that they are distinct, RO being about worship and RME about education. With the increase of political figures intent on division, it is of most importance that young people continue to be educated on different cultures, faiths and practices. This is not the same as worshipping those faiths. As we learn about different historical events and about different countries and cultures, I believe it is essential that young people learn as much as they can to enable them to transition into a diverse world. I believe this was put best by Claire Benton-Evans of the Scottish Episcopal Church, who stated, "Our children need to understand other faiths, beliefs and cultures if they are to grow up in the diverse, inclusive and tolerant society that we want in Scotland." Indeed, on this point, the evidence from stakeholders across the board was clear, as both faith-based and secular organisations argued for the moving the option to withdraw from RME from the bill. As a result, the committee therefore urges the Scottish Government to reflect further on this approach and bring forward amendments at stage 2 to provide that withdrawal only applies to RO. Nevertheless, the purpose of this bill is to increase the rights for children, and as such, it was noted that the majority of those who offered a view on whether the bill should be amended to include an independent right for children to opt out of RME supported giving children that right. However, the responses to the Scottish Government consultation differed in their support for an independent right to withdraw from RO. Therefore, most of the committee felt that it would be more appropriate to progress with the right for children to object to their parents' withdrawal of them for RO and RME alone, but would welcome the Cabinet Secretary giving further consideration to the previous point. On the point about its compatibility with the United Nations Convention on the Rights of the Child, a majority of the committee recognises that it would have been preferable if the bill had been drafted in such a way as to bring its provisions within the scope of the UNCR Act. On the second part of the bill, to amend the United Nations Convention on the Rights of the Child, So that public bodies are not conflicted between complying with the Act and other Scottish legislative duties, the committee notes there are very strong concerns about the rationale for it, the precedent it is set, and whether the bill is an appropriate vehicle for these provisions. Overall, Presiding Officer, the committee does support the premise of the bill to improve the rights for young people, and the majority supports the general principles of the bill. That being stated, significant amendments will be necessary as serious points have been raised throughout both Part 1 and Part 2. Therefore, I will support the bill progressing to Stage 2, but much work requires to be done on the bill to further the rights of children. Thank you.
Thank you. I now call Ros McCall to be followed by Davy Russell. Up to 6 minutes, please, Ms McCall.
Thank you very much, Deputy Presiding Officer, and I'm very pleased to speak on this Stage 1 debate today. This bill raises profound questions on how we balance children's rights, parental responsibilities, and the practical realities of delivering education in a Scottish classroom. And at the outset, I want to be absolutely clear. Children must have a say in their education. Their voices matter, their experiences matter, and their well-being, particularly their emotional well-being, must guide our thinking. Scotland has rightly taken steps over many years to ensure that children are listened to, and that's something I wholeheartedly support. But this bill is asking Parliament to make significant changes on how families, schools and children navigate decisions about religious observance and religious and moral education. And we've already heard that those two are not the same. And these are deeply personal areas of a child's education, and any changes must treat families with the respect that they deserve. Presiding Officer, Scottish Conservatives absolutely believe that children should be heard in decisions that affect their lives. Their voices matter. Their experiences matter, and their well-being, emotional and otherwise, must always be taken at the heart of what we do. But listening to children must also sit alongside practical, common-sense approach that respects the crucial role parents play in shaping their children's upbringing. It should not create conflict, it should not place new emotional burdens on young people, and it should not put teachers in the impossible position of having to navigate family disagreements. And that's what this bill does. The proposed process where schools must inform a child of their parents' withdrawal request, then they gauge the child's capacity, gather their views, and then potentially override the parent. Now that might look tidy on paper, but in a real school with real families and real pressures, this is far from straightforward. And stakeholders were crystal clear. As Susan Quinn of the EIS warned of significant concerns about resources, workload, and the impact on relationships. And Douglas Hutchison described the practicalities as burdensome for the school and onerous for the child and parent. And teachers across Scotland working every day with children of vastly different developmental stages have said plainly that this will be hard to implement consistently or fairly. And we cannot ignore that reality. We cannot legislate in a way that sounds good in theory but causes stress and confusion in practice. We must put children's well-being at the forefront to not create situations where a child feels torn between their parents and their school, or responsible for making decisions that they may not be emotionally ready for. Presiding Officer, respect must be the thread running through all of this. Respect for parents as primary educators, respect for teachers as professionals, and respect for young people as developing individuals who need guidance, not pressure. Religious and moral education, and indeed religious observance, play an important role in helping children understand different cultures, beliefs, and worldviews. As Claire Benton-Evans reminded us, children need to understand other faiths, beliefs, and cultures to grow into the inclusive and tolerant citizens that we want for Scotland. And this is about fostering understanding, not promoting doctrine. In a time when division and misunderstanding are so easily amplified, removing children from opportunities to learn about other people risks deepening social fractures. We should be encouraging tolerance, not unintentionally narrowing young people's lessons. But again, we must approach this with common sense. The number of withdrawal requests is very small, around 4,000 children across Scotland. Yet the bill would introduce a legal complexity, administratively heavy process that affects every school, every teacher, and every family, regardless of whether they've ever considered withdrawing. And that's not proportionate and it's not practical. So, Presiding Officer, the Government's proposal to amend the UNCRC compatibility duty raises further questions than it answers. Stakeholders, including the Law Society, have said this bill only addresses part of the issue. Crucially, there's still no clear example of where such conflict in Scots law would arise. And yet here we are, placing another layer of complexity onto public authorities without clear justification. At a time when schools are stretched and teachers are under pressure, and we should be doing everything possible to support them, this bill risks adding confusion rather than clarity. Presiding Officer, we should all share the intention of strengthening children's rights. The rights must be implemented in a way that supports families and not strains them, in a way that considers children's emotional needs, not burdens them, and in a way that respects the vital partnership between parents, teachers, and schools. This bill, as drafted, doesn't strike that balance. It doesn't provide the clear safeguards or common sense guidance required to protect relationships and well-being. And despite its intentions, it risks creating confusion, inconsistency, and conflict. We need an approach grounded in common sense, clarity, and genuine respect for all those at the heart of education, and that's parents, teachers, and of course, our young people. Thank you.
Thank you, Ms McCall. I now call David Russell to be followed by Bill Kidd. Up to 6 minutes. Mr Russell.
Thank you, Deputy Presiding Officer. I have no objections to Part 2 of the bill, other than to reiterate the committee's reservations about why both parts of this legislation are being put through together. However, I do have questions about the pairing of the religious observance and the religious and moral education within the bill. After all, Equality and Human Rights and Civil Justice Committee accepted that it should be possible to withdraw from religious observance, but the majority were opposed to the idea that children could be withdrawn from RME. Indeed, even some secular organisations agreed with this. Now, the Scottish Government may have their own reasons for lumping RO and RME together, and I would welcome some reasoning behind it. But if this is the case, that there are too many elements of the RO within RME, then surely this bill is throwing the baby out with the bathwater, and wouldn't stronger guidance on what constitutes a breach between the two be a welcome first step? And if there were strong dividing lines, then this would allow children with diverse faith and non-faith backgrounds to still learn about the world around them. The other issue, and I think this is probably the strongest reason that more work is needed on this bill before coming back to Parliament, is that it will put added pressure on teachers and schools without any additional help. While there is a need for parents to have a say in their children's education and respect the wishes of those children, this is not the mechanism that can make that happen. We should not ask schools to be intervening in this way. I mean, you know yourself, anybody's got kids. They change a class, they change friends, and all of a sudden, what they were, for 1 week may not necessarily what they're up for the next week. So it's actually complicating things. If the Scottish Government does not want to have the wishes of the children taking primacy, then it should show some courage and ask Parliament to vote on that. Finally, on this matter, the one-sided approach that gives 2 opportunities to attend RME and RO, but only 1 chance to abstain. If the parents can say their child should not attend RO, but the child says that they should, then shouldn't the reverse be also true? Given that most recent census pointed to 51% of the people declaring that they belong to no religion, a figure that has been growing over the years, this imbalance seems counter to the direction of the country. My view is that there is something objectionable about RME, for example. that it too closely resembles religious observance, then perhaps this should be addressed in isolation. And if intention is for children to be able to unilaterally withdraw from RO as part of their school timetable, then the Scottish Government should not pass the buck on to teachers and schools. It should lay this out for the Chamber to vote on too. For me, there is too many unanswered questions. The committee are not convinced that this bill is evidence-based, and I do not feel that what is being proposed will work for schools, parents or the pupils. Basically, parents will not let this rest if we happen to pass this legislation and there's a difference between their child and themselves, and the schools will end up being in the middle of this, and it will only cause disruption. So today I will be abstaining on this bill. Thank you.
Thank you, Mr Russell. We now move to the final speaker in the open debate, Bill Kidd. Up to 6 minutes. Mr Kidd.
Thank you, Presiding Officer. At its heart, this bill is about strengthening the rights and voices of Scotland's children, something this Parliament has committed to repeatedly over the years. It seeks to make two targeted but meaningful changes, and although somewhat technical in nature, the impact will, I hope, bring meaningful change to the everyday experience of children in our schools and in the way our public authorities understand and uphold the United Nations Convention on the Rights of the Child. It aims to ensure that, in the context of the long-standing parental right to withdraw a child from religious observance, children's and young people's views are taken into account. Article 12 of the UNCRC gives every child the right to express their views freely in all matters affecting them and to be heard, not listened to as a courtesy, not nodded to in passing, but given due weight. Now, Part 1 introduces a legal requirement for schools to inform children when a parent seeks to withdraw them from religious observance or religious and moral education, and to ensure their views are considered in that process. Importantly, however, it maintains parental rights at the same time as strengthening children's rights. It attempts to strike a balance between the two, and I welcome that. Religious observance and religious and moral education play different roles in our education system, but let's remember we are not debating the value of these subjects today. We are debating the right of a child to be heard about their participation in them, and that right matters deeply. Part 2 of the bill might seem more technical, but is no less important. It ensures that the UNCRC Incorporation Scotland Act 2024 can operate in a way that protects both legal certainty and the continuation of essential public services. It introduces an exemption for public authorities when they face a direct conflict between the compatibility duty and an act of this Parliament. This is a proportionate step and one that allows the UNCRC framework to function clearly and fairly. Indeed, the UN Committee on the Rights of the Child has always emphasised that incorporation must be workable, accessible and coherent. Presiding Officer, the Government has undertaken wide-ranging consultation on this legislation, engaging with ADES, the Humanist Society of Scotland, the Scottish Catholic Education Service, STARM, and together alongside faith and belief organisations and members of the Scottish Youth Parliament. This level of engagement shows both the sensitivity of the subject and the commitment to listening to all voices, including those too often unheard. Of course, no legislation is perfect at stage 1, and I understand the strong feeling of many that the legislation does not go far enough. Indeed, I have received a number of constituent inquiries looking for the Scottish Government to amend the bill to give pupils an independent right to opt out of religious observance, which I raised in writing with the Cabinet Secretary. In reply to these concerns, the Cabinet Secretary stated that, as we will all be aware, the parliamentary process provides stakeholders and all those with an interest in the bill to put forward their case for amendments. Throughout this, ministers will continue to discuss these issues with Parliament and other interested parties, and I will consider all the points made in both the written and the oral evidence from those who were invited to give evidence to the committee. And I understand that the consultation raised concerns around how an independent right for pupils would be balanced with parental rights. I also understand that in response to the Humanist Society Scotland report, Preaching is Not Teaching report, the Cabinet Secretary met with the Humanist Society of Scotland and has asked them to share further information on their examples of religious observance not being delivered inclusively. Therefore, I understand the conflicting opinions involved and would urge all parties to raise these issues at stage 2. This bill takes careful steps to ensure a child's voice is part of decisions about their learning and their identity. It strengthens clarity for public authorities implementing the UNCRC, and it reinforces Scotland's continued journey toward making rights real, not only in principle but in practice. Presiding Officer, children do not ask for that much. Well, most of the time, they ask to be heard, they ask to be respected, and they ask for adults, parents, teachers, lawmakers to make decisions with them and not simply for them. By supporting the general principles of this bill, hopefully we can go some way to showing them that their voices matter, that this Parliament listens, and that Scotland continues to take seriously its duty to uphold the rights of every child. Therefore, I urge members to support the bill at stage 1, and thank you very much.
Thank you, Mr Kidd. We will now move to closing speeches, and I call on Maggie Chapman to close on behalf of the Scottish Greens. Up to 6 minutes, please.
Thank you, Presiding Officer. In closing this afternoon for the Scottish Greens, I'll deal with some of the issues I did not address in opening. First, my thanks to my committee colleagues and our clerks, Spice and Pact colleagues for the thoughtful consideration of this bill at stage 1. I am very grateful to all those who sent in their views or contributed in person to our evidence sessions. Thanks too to all who sent detailed and informative briefings in advance of today's debate. This seemingly small bill wrestles with some big questions. I have already made clear that I will seek at stage 2 to separate religious observance and RME and to introduce an independent right of any child to withdraw from RO. These two positions are consistent with most of the evidence we heard at committee and with the views of the majority of Scots. Turning to part 2 of the bill, Martin Whitfield, Alex Cole-Hamilton and others spoke to concerns I share. I am very concerned that part 2 fundamentally undermines the principle of enshrining UNCRC into Scots law, as this Parliament has voted to do twice, in 2021 and 2023. So let's be clear about what part 2 does. In a bill which seeks to ensure that one of our laws is consistent with UNCRC, it allows public officials to ignore the Convention where there is a conflict between it and any domestic Scottish law. The Scottish Government has been unable to say why this is necessary. It has already indicated that there are no existing laws or policies it is aware of where there is a conflict with the Convention. So it's not clear why this part of the bill is needed at all. Why would this Parliament choose to pass legislation that was not compliant with UNCRC? And if any future conflicts do arise, Scottish Greens are not convinced this is the best way to deal with them, and certainly should not be the default. If the Convention is simply set aside every time there is a conflict, then what was the point of enshrining the Convention into our laws in the first place? Witnesses told the committee that it sends out entirely the wrong message, for one of the first acts in implementing the UNCRC is to set up a system of carve-outs from it. Surely it would be better to have a clear process by which we can amend legislation so it becomes consistent with Convention rights. Or better, just ensure that all bills we pass are drafted to be consistent in the first place. Because this also has potentially huge implications for a future Scottish human rights bill. It risks setting a precedent whereby we enshrine rights and then establish processes for public bodies to ignore them. I therefore ask members to consider carefully whether decisions we make as this bill progresses will affect a future human rights bill. We cannot endorse a process that creates a mechanism to set aside human rights. Too many individuals and communities across Scotland currently struggle to realise their rights or frequently have their rights ignored. These groups have waited for too long for watertight legislation that safeguards their rights. Can I turn to a couple of other issues that have been raised this afternoon? We've not heard much discussion on the potential for othering and stigma that exists within the current system, nor have we heard much about how school staff can be better supported to ensure the young people in their care can realise their rights. Indeed, the committee heard some very troubling evidence of quite inappropriate behaviour in our schools. And the Scottish Government does not have a clear handle on all of this. The Government has asserted that, and I quote, religious observance is inclusive, subjective and pluralist. But it actually has no way of knowing this. It hasn't done the research to gather evidence to back this up. And I urge them to do so immediately to remedy this. Just to reiterate the Supreme Court decision from last week, judges ruled that collective worship in the north of Ireland, which isn't objective, critical and pluralistic, amounts to indoctrination and is unlawful. I appreciate the Cabinet Secretary has written to the committee and confirmed today that the context of the north of Ireland is different in both legal and educational religious terms. This is true. However, that doesn't mean to say this court case does not have implications for us here. Indeed, Professor Russell Sandberg, an expert in religion and the law, has said, and I quote, "The decision is about the right to withdraw and whether opt-outs for parents can excuse teaching that is otherwise not human rights compliant. In this respect, it is an important decision in Northern Ireland and beyond, especially where considerable reliance is based on the existence of opt-outs. This is arguably true of the law on collective worship in schools in most, if not all, of the nations of the UK." So, Presiding Officer, this bill is in many ways disappointing. At the first opportunity, the Scottish Government has chosen to draft this legislation to be out of scope of our UNCRC Incorporation Act. It does not implement the recommendations of the UN Committee on the Rights of the Child, and it suggests that UNCRC compliance might be optional. But we can remedy these issues at stage 2 and beyond. We will have a lot of work to do to make sure this bill measures up, but I believe it is possible to do that work. And for that reason, we will be supporting the bill at stage 1 later this evening. Thank you.
Thank you, Ms Chapman. I now call on Rhoda Grant to close on behalf of Scottish Labour. Up to 6 minutes, please.
Thank you, Presiding Officer. This was an interesting debate, and my computer's not working. I have a backup. Oops, sorry. It was a really interesting debate, and many people have expressed concerns about the bill, and those were highlighted today. I think indeed it's clear that even those members of the committee that supported the bill heavily caveated that support, so there's much to deal with. The bill was supposed to bring RO and RME into line with the UNCRC, which was something I believed we could have signed up to, but unfortunately the bill doesn't really do that. Martin Whitfield, Pam Duncan-Glancy, Davy Russell and others pointed out that the bill conflates religious observance with religious and moral education. Religious observance is taking part in religious practice, prayers, religious instructions and the like. And it's very easy to see why people practising a different faith might not want their children to take part in that religious observance. Many speakers talked about religious and moral education being education about faiths and practices. It builds understanding of all the main faiths and beliefs, giving children deeper understanding of what their own peers may believe. And such education provides knowledge, hopefully cuts through myths and builds better understanding of other faiths, as it does not ask children and young people to practice those faiths. David Russell pointed out that if there are grey areas with regard to religious and moral education, that could be dealt with in guidance rather than in legislation. Because the bill conflates those two subjects. One should have an opt-out and the other forms part of the curriculum, which should not have an opt-out. And I believe many of the speakers today held that view. Part 1 of the bill seeks to allow a child to opt into religious observance of religious and moral education if their parents firstly opt them out. And on the face of it, it sets up a conflict between the parent and child. Miles Briggs spoke about that. But one, if we're being really fair, is unlikely ever to be a reality, because children are more likely to want to opt themselves out against their parents' wishes. And parents would rightly be concerned that the children be given a right to refuse to practice their parents' chosen religion. And I don't believe that could easily be added at stage 2, because it wasn't properly scrutinised at stage 1. And it's much more difficult to deal with when there's a conflict between the rights of the child and the rights of a parent to bring up their child. It takes much more than a short stage 2 amendment to deal with that, as pointed out by David Russell. And Pam Duncan-Glancy also spoke about teachers and having to decide whether a child had the capacity to make these decisions. And that's an extra burden on teachers. So we need to make sure that the legislation works. And as Alec Cole-Hamilton said in his comments about Article 12, that everything we do must have a children's views held at the heart of it. So it actually begs the question, do we need this legislation already if we're already bound by that? The legislative flaw in Part 1 is that it amends the Education Scotland Act of 1980, which is an act of the UK Parliament, and all, as we know, all UK legislation is out of the scope of the CRC Act. And if we think back, 1980 was at a time where it was still legal to belt children in school. That is a really old act and legislation. So the legislation that is drafted to bring religious education under the scope of the UNCRC Act itself doesn't actually itself come under the scope of that Act, and therefore no one can challenge this bill under the terms of the UNCRC Act because it's not itself compatible. Putting this right, I think, in my opinion, is beyond the scope of this bill and beyond the scope of Stage 2, because the way we deal with this is by bringing forward new standalone legislation rather than amending an act which is out with the scope of previous legislation. I don't think the bill can be amended to make it compliant. Many speakers talked about Part 2 of the bill, and this kind of takes it to a whole new level, because it's not about religious observance or religious and moral education. It's about creating an opt-out of the UNCRC Act itself. And Martin Whitfield pointed out that what it really is doing in practice is giving a public authority the ability to breach a child's human rights. And that's surely not right. Public authorities are currently bound to act in compatibility with the UNCRC Act. And this part of the bill gives them the opt-out from that, which begs the begs the question, what is the purpose of the UNCRC Act at all? If I've got time.
Very briefly, Cabinet Secretary.
I'm listening to some of the points Ms Grant has made in relation to Part 2 of the bill. And I've heard comments from members throughout the course of the afternoon that support her view. But she must also be recognising that a number of organisations, including Together, the Children's Commissioner, UNICEF, support this element in the legislation. Why are they wrong, and why does Ms Grant believe this can't be resolved further at Stage 2?
Rosa Grant.
Because I believe it is in direct conflict with the UNCRC legislation. And it kind of calls into question why this is here already. We know that the UK government sought the exception because it was beyond the devolved powers. But surely we have legislated for the future of what happens here in Scotland. And indeed, when we asked in committee what were the issues that the Cabinet Secretary foresaw that we would need this legislation, she couldn't name one. And it's about future-proofing. Well, surely in the future we should not be looking at legislation that is not compliant with the UNCRC. So this bill should not, this part of the bill should not be required. So, Presiding Officer, we don't think this bill can be amended to make it compliant. We would really need standalone modern legislation that takes account of all of this, and therefore we'll be abstaining tonight.
Thank you, Ms Grant. I now call on Stephen Kerr to close on behalf of the Scottish Conservatives. Up to 7 minutes, please.
Presiding Officer, whenever we discuss anything in this chamber that refers to religion, I always feel I should be transparent and refer members to my entry in the Register of Interest as a member of the Church of Jesus Christ of Latter-day Saints. But let me say quite clearly, I don't speak on behalf of the Church or its leaders or its members. I speak today in my own right as a Conservative member of this Parliament, but also as someone who I hope would be regarded by others as a person of faith, but someone who believes profoundly in the family and in the rights and responsibility of parents. And I've intervened a number of times in the debate in order to bring the issue of the rights and responsibilities of parents to the fore in our proceedings. Presiding Officer, this is an extraordinarily long, short name for a bill, so I'm not going to try and repeat it. But I do object to the bill profoundly. I think that nearly all of the speeches, actually, in this afternoon's debate have highlighted inconsistencies, failings. And when we get down to the detail of the apparent contradictions that are being created by an attempt to course a middle way, or third way, as it used to be called, I have to say that I really think it would be a better part of wisdom on the Cabinet Secretary and the Scottish Government to take the bill away. It's not ready to be discussed. We have too many pieces of legislation that appear at stage 1 debates and then are severely criticised. And by the time we get them through the legislative process, they look absolutely nothing like the original bill. I can't see the point of that. Take the bill away, take it off the table, and come back at a later date, probably in the next session, with something that is more considered and more consistent. This is not just a technical tidying up exercise. It's just not. It's not a benign update to long-standing legislation. I see this very much as a fundamental challenge to the rights of parents, to the integrity of the family, and I would argue the proper limits of the state. And let me explain why. And by the way, I think Pam Gossel was right. This approach, which I think is muddled, is not inconsistent with the SNP's long and rather troubling record of attempting to replace the role of parents with the authority of the state. Because the central mechanism of this bill lies in Section 1, which inserts new sections, as has been said, into the Education Scotland Act 1980. But it does something unprecedented. It subjects the long-standing parental right of withdrawal from religious observance and religious and moral education to the veto of the child. Under this proposed bill, schools must inform the pupil that their parent has exercised the right to withdraw them and must tell the pupil they have a right to object. Now, if the child does object, regardless of age, regardless of maturity, regardless of parental conviction or responsibility, the parent's decision is simply set aside. And the withdrawal is, quote, not to be given effect to the extent of the pupil's objection. Presiding Officer, this is not listening to children, as is often the way that this particular treaty is dressed up. Of course I will.
Martin Whitfield.
I'm not sure that the description of the Act actually has been put there is accurate. Isn't the challenge that what you will end up with are two positions that effectively someone in the school is needing to arbitrate between? And the challenge is that the arbitrator is probably the last person who needs to be involved in trying to seek a decision of supporting the parents and their rights, or indeed the children and their rights.
Absolutely right. I think teachers generally, school leaders in general, don't want to be put in that position. That's what this is what this bill does. And I'm also afraid, Martin Whitfield, that has raised a really important point, but I'm really concerned, Presiding Officer, that this is weaponising children, potentially, against their parents in matters of conscience and belief. And it's inserting the state into the heart of family life, elevating the child's immediate preference above the parent's settled moral and spiritual responsibility. And as a Conservative, and as I've already said, a person of faith, I cannot overstate how alarming this is. Because for centuries across Scotland and the rest of the UK, and indeed every liberal democratic society, the family has been understood as the primary community, the foundation of moral formation, education, identity and belonging. Parents are not optional participants. They are not obstacles to be worked around. They are responsible for raising their children in line with their religious, moral and philosophical convictions. And the importance of that parental role rests on a principle that has been recognised across the generations. that parents have the primary right and responsibility to direct their child's religious and moral education in accordance with their own conviction. And this bill overturns that hierarchy and, as Martin Whitfield says, creates an arbiter in terms of the school, teachers, and indeed it empowers the state and it distorts the meaning of children's rights into a mechanism for undermining family authority. Let's be absolutely clear. This bill interferes directly with a parent's freedom to raise a child within their faith or philosophy. And for millions of people across Scotland, faith is not a private hobby. It's foundational to culture, identity, community and moral development. Now, if the government believes that somehow this principle should be undermined, it raises the inevitable question: where does this end? Because what this bill creates is not a limit. It's not limited to religious observance. It's not limited to RME. It creates a model in which a child's immediate preference is elevated above the parent's long-term judgment, in which the school staff become the arbiters between the parent and the child, in which the state asserts itself as the higher authority over the family. I actually thought that Davy Russell's contribution in this respect was absolutely bang on the money. He injected a much-needed dose of reality into the proceedings of this Parliament, where he described what every parent knows about our children as they grow up. You know, they can be incredibly... adults can be very
Mr.
fickle.
Kirk, could you please bring your remarks to close?
Adults
You're over
can
your
be
time.
very fickle, but I can agree with Davy Russell that children can be too. Well, look...
Please conclude. You're over your time, Mr. Kerr.
I am concluding. I am concluding by saying that Scotland's families don't need the state to sit in judgment over their values. This bill is wrong in principle, wrong in detail, and it's wrong as it stands for Scotland, and the Cabinet Secretary would be well advised to take it away before it ends up being challenged.
We will now call the Cabinet Secretary to close on behalf of the Scottish Government. Up to 8 minutes, please.
Thank you, Presiding Officer. We've heard a number of contributions this afternoon. I want to come to them in due course, but I would like to highlight the support from a number of stakeholders for the intention and the general principles behind this evening's bill that we are debating. Those include the Humanist Society Scotland, who wrote to the committee to express their support for the general principles of the bill, and Together, Scottish Alliance for Children's Rights, who highlighted in a recent briefing for MSPs that the bill is an opportunity to take practical steps towards stronger protection of children's rights across Scotland. Given the bill's subject matter, perhaps most importantly, children and young people consulted also broadly support the intention behind this bill. I will tomorrow meet with faith and belief groups, and throughout the passage of the bill, dependent of course on this evening's vote, I will continue to engage on a cross-party basis as I have listened and reflected on a number of points that have been made this evening, to which I now come. I think Mr Cole-Hamilton, Mr Whitfield and Paul McLennan asked about the rationale behind the bill. The bill is necessary because it gives Parliament a real opportunity to strengthen children's rights. The UNCRC Act 2024 is a landmark, but the incorporation is not in itself a single event. It's a process of building that clearer, more workable framework that protects children's rights in practice. The bill is part of that work. Now, as we've heard this evening, yes, I will do.
Alex Cole-Hamilton.
The Cabinet Secretary for taking my intervention. She is right to reference mine and Martin Whitfield's contributions questioning the rationale for the bill, but it's not the rationale behind Part 1, which fundamentally we broadly agree with, albeit with the need of some amendment. It's the rationale behind Part 2, which we fear creates a backdoor by which aspects of the UNCRC or the UNCRC in its entirety could be disapplied in certain circumstances.
Cabinet Secretary.
I thank the member for his point. I think the point that's been made, and I responded to Mr Whitfield on this earlier on, the carve-out that's being proposed, or the approach in Part 2, is very reflective of the same approach that exists on the Human Rights Act, and it's very limited in terms of its scope. And it is a future-proofing power that exists in the legislation. But I have listened to members' views on this throughout the course of the debate, and I'm content to continue to engage on that point, as members have raised a number of issues in that regard. happy to do so.
Martin Whitfield.
I welcome the Cabinet Secretary's confirmation of how she intends to approach this moving forward. I genuinely do welcome it. Is she still confident, though, that the certification she gave under Section 23(1) of the UNCRC is in fact compatible when we are agreeing to disapply the UNCRC?
To confirm, Presiding Officer, I wouldn't be able to bring it forward were it not compatible. That's the advice I received from officials. So all ministers and government have to bring forward legislation that is compatible to that end. If I can move on to some of the other commentary that was shared with the Chamber this afternoon, Pam Duncan-Glancy, I thought, quite rightly spoke about the lack of data that we have at the current time. A number of other members mentioned this point. The data we do have in relation to withdrawal from RMO and RO and RME, rather, shows levels of withdrawal for the subjects are incredibly low, an estimated 0.59% of pupils across Scotland. And I agree. Yes, I will do.
Maggie Chapman.
Not going to make much progress here.
I thank the CABSEC for taking my intervention. I hear what she's saying about data, but what we also heard clearly in committee was that there isn't actually consistency in how that data is collected. So we don't know if that data reflects the real numbers, and we also don't know what happens to those children who are withdrawn.
Cabinet Secretary.
Well, indeed, I was coming to that point because the issue around about data collection is something that Ms Duncan-Glancy and I debate and discuss pretty regularly, but it's not limited to this bill. It exists in a number of other aspects in relation to Scottish education, particularly in our schools, whether that be in additional support needs, whether it be in relation to recording bullying events. So I think there's actually a lack of national data at the current time. It was a point I think Rhoda Grant picked up on in relation to the 1980 Acts and how it interacts. That's one of the reasons why John Wilson, a former head teacher, is carrying out an independent piece of work, which I updated the committee on when I gave evidence, to look at how we provide for school governance and we fund our schools. These aspects are really live and relevant to that point. But to give Ms Duncan-Glancy and Parliament confirmation, I have instructed officials to gather further data on this point because I agree with the points that she and others have quite rightly raised today. The convener spoke to the complexities associated with the bill and quite rightly spoke about the Scottish Government's approach to driving forward at a middle road between competing views on these matters. And as Cabinet Secretary, I have been incredibly mindful of that throughout this process. Mr Briggs, I think, was provided with an assist from Mr Whitfield early on in the debate, who claimed the bill would add to teacher workload, and a number of others made this claim. I think that assertion fundamentally misunderstands what this bill proposes. If anything, we can expect more young people to be opting in, not out of RO and RME. I also... Would Mr Briggs like to give way?
Miles Briggs.
The Cabinet Secretary has just made that statement. Following a statement, she says we don't have data. So it seems a bit ridiculous to say that fewer will opt out when we don't know how many are opting in or opting out. The hokey-cokey, as I described earlier, around this bill, and what that means for schools. Who will be responsible for these young people when they're not in either classroom or in RMO? And I think that's where I'm not sure the Cabinet Secretary really knows the impact of this bill.
So I think Mr Briggs is completing two separate matters and deliberately trying to insinuate that the bill is about more young people opting out of religious education or religious observance. That's not the case. The right still rests with the parent, and it is the case that the legislation will now ensure that children's rights are taken cognizance of. In terms of the numbers, the Scottish Catholic Education Service, who I've engaged with, I'm sure Mr Briggs has well, was keen to make the point to me that the numbers nationally are incredibly low. However, I did commit to Ms Duncan-Glancy on us interrogating that data further. I would like to make some progress as I have 2 minutes left, Mr Briggs. But I'm also thoughtful about my own engagement with the Church of Scotland on this point, who were keen to state to me that teachers regularly and routinely discuss these issues with children and young people, and we should be mindful of the professional capabilities that are also at play in that regard. Now, Martin Whitfield will be assured that the children and young people, of course, can still challenge the actions of public authorities. The exemption that we've heard a number of different points on this afternoon helps to look at where the legislation is the problem, so we can help to protect our children and young people's rights whilst recognising where there may be conflict in terms of the delivery of services. Now, while Parliament can't control the evolution of the legal interpretation of what is happening in the future, much of the purpose behind Part 2 is really to avoid that disruption to essential services, and it would not be fair to hold public authorities, like our local councils essentially, responsible for simply following the law. But also to the points that have been raised this afternoon, we have published the Children's Rights Scheme to ensure that there is a process for identifying potential legal incompatibilities. Presiding Officer, I am extremely mindful of time, and forgive me, I have not managed to get to a number of contributions from other members, which I thought were worthwhile recounting, not least in terms of Maggie Chapman's views, and I'd be keen to engage with members as the bill progresses through Parliament. But in closing, I do want to conclude by encouraging us all to reflect on why we, as an increasingly secular society, seek to continue to enable religious observance and religious and moral education in our schools. Enabling school communities to come together to share common values, to engage with other faiths and beliefs, aids understanding, tolerance and acceptance. The same applies with religious and moral education for individuals, allowing children and young people at different ages and stages to learn about others' values and beliefs, and such understanding and awareness is really vital to encourage tolerance, to invite respect and to address prejudice. And, Presiding Officer, it is arguable that fostering and nurturing this sort of opportunity for cohesion in our schools is needed now more than ever to better equip our young people to handle the increasingly turbulent and fractured society that they will enter as adults. I move then that the Parliament agrees to the general principles of the Children Withdrawal from Religious Education and Amendment of UNCRC Compatibility Duty Scotland Bill.
Thank you, Cabinet Secretary. That concludes the debate on the Children Withdrawal from Religious Education and Amendment of UNCRC Compatibility Duty Scotland Bill at Stage 1. It is now time to move on to the next item of business.